Blackburn. Senator Lee.
Thank you, Mr. Chairman. Judge Merriam, I'd like to start with you, if that's all right. In 2017, you presided over a case involving the Fair Labor Standards Act. I believe this was while you were a magistrate judge before you became a district judge. In a ruling issued in the context of a motion in limine, you barred the defendants from introducing evidence offered by the plaintiff's immigration status at trial. And your statement accompanying that ruling was, quote, that, quote, precluding evidence of plaintiff's immigration status furthers the purpose and intent of the Fair Labor Standards Act. If you remember that case, what did you use to determine the purpose and the intent of that statute?
Thank you, Senator. I don't recall that case, and I'll just accept that I said that in a motion in limine ruling.
Right.
So there's a great deal of case law on the purpose of the FLSA, and that's in large part because courts are required in most circumstances to approve settlements under the FLSA. And so there is a fair amount of law on the question of the purpose. And the Second Circuit law on that talks about the purpose as being ensuring that that hourly workers in particular are paid their proper wages under state law.
Right. So what sources do you generally use when you're undertaking that kind of inquiry to figure out what the purpose of an intent of that statute or any other statute is? Thank
you, Senator.
Can that ever override the language?
Oh, absolutely not. No, the language of the statute controls.
Let's talk about the Ninth Amendment for a minute. When you came through this committee about a year ago, in the written questions that I submitted to you after your hearing, I asked, does the Constitution protect rights that are not expressly enumerated in the Constitution? And your response read as follows, quote, the Ninth Amendment protects against the infringement of unenumerated rights, suggesting that those rights must be protected. What specific rights has the Supreme Court identified as flowing from the Ninth Amendment?
Thank you, Senator. I think most of the areas of law where the Supreme Court has recognized unenumerated rights depend on sort of a constellation of amendments, and those are largely, they're summarized, I think, best in Glucksberg, and they involve things like the right to parent your children and dictate their education, marital privacy rights, things of that nature.
Troxel, for example. Any rights that have been found independently as flowing from the Ninth Amendment and no other source?
You know, as I sit here today, Senator Lee, I can't recall one, but I can't speak to that right now.
Okay. On February 1st, President Biden said that he was looking for, in that case, a Supreme Court nominee with, quote, a judicial philosophy that is more one that suggests that there are unenumerated rights to the Constitution and all the amendments mean something, including the Ninth Amendment, close quote. Do you share that judicial philosophy that President Biden described?
Thank you, Senator Lee. I'm not familiar with the comment from the president, but I can tell you this. My only judicial philosophy is that the text of a document, the Constitution, a statute, or a rule, and binding precedent are what guide me. Rule of law and predictability are what matters.
Okay. Ms. Montecalvo, what are the elements of Article 3 standing? Article 3 justiciability, including standing.
Thank you, Senator Lee. Article 3 standing plaintiffs must show an injury, causation, and then there must be redressability. The federal district court must have a way to remedy the situation.
And what are some of the other infirmities that can interfere with, assuming standing has been met? What else can take something out under the justiciability doctrine?
Thank you, Senator. I was thinking as I gave my answer, and then courts must always consider mootness, and an issue must be ripe as well.
What role should the text and contemporaneous understanding of a statute or provision of the Constitution play in the interpretation of those provisions?
Thank you. I would echo Judge Merriam's words, which is that the plain language of the text controls, and that is absolutely the only place to begin the analysis. And if I were confirmed to this position, that's where I would
Right.
start.
Yeah, no, I get that. I respect that. And I don't think anyone would disagree with that. But what role should the text and the original understanding of it, the understanding at the time of enactment if a statute, or at the time of ratification if a provision of the Constitution, what is that original understanding? What role does that play?
Thank you. The Supreme Court has said, both in Heller and in Crawford versus Washington, that the plain public meaning of the text of the Constitution will control the court's analysis, and that is the precedent that I would follow in those cases.
As understood at the time of enactment or ratification?
Yes, Senator.
Okay. Thank you. I see my time's expired, Mr. Chairman.
Thanks, Senator Lee. Senator Blumenthal.